We're gonna talk about something very interesting, because I call it interesting now because we are getting into a neck-to-neck timeline. The timeline is coming, and the CPRA will go live 1st of Jan, right? So we don't have a lot of time now. Now, a lot of people also ask me, is the world going to change after that? Definitely not for companies who are already GDPR compliant, CCPA compliant, right? Things are changing for them. For GDPR compliance, compliant companies, lesser things are changing, but for CCPA compliant companies, a bit more changes are coming. Companies who are non-compliant, a lot of things are coming for you. So, so, and that is something that it's something that there is a chicken egg game, probably, how much compliance it happens and what level of percentage of compliance. So a lot of times when I also go to offices now of DPOs and they call me and they say, Aakash, tell me what percentage of compliance I've reached, right? I want a metric, and it's so difficult to figure out a privacy metric because it's, even the biggies of the world are making metrics and people are questioning them. So, but we have developed a metric, interestingly, and we are working on it with some data in terms of how many DSRs came, how fast did we respond to it, notices are there or not, are notices compliant or not, were they reviewed or not. So we have built something. So our clients doing it, but just saying it's everything is so complex, right? It's not straightforward. So yeah, I think we will get to the session then, and we have 50 people. So I think 50 is a good number, right? It's lucky. So today I taught the 50th batch of CIPP at Tsaaro Academy. So, and I just realized it's 50, and so yeah, it's interesting. Number 50 is getting lucky for me, right? So I think I should be thinking about that. So we have with us. So let's start the session, guys. I know we waited for some time, but people who are going to miss this are just going to go to YouTube and watch this, right? My name is Aakash Singh. I am CEO and co-founder of Tsaaro and Tsaaro Academy. I am also part of IAPP Advisory Board, a fellow in information privacy, a CIPP, CIPM, but a privacy implementer by profession, right? I do privacy implementations around the industry. The company that I represent is, again, Tsaaro. So Tsaaro is a privacy consulting company. What we do is we do things like privacy compliance programs, something around DSRs, something around policy making, gap assessments. But yeah, mostly anything and everything in privacy is something that we do. We are also #1 privacy academy in India. So if you think about a course of privacy, I think that is Tsaaro Academy. But moving ahead, right? Moving ahead to the person in charge for the session today, right? Mr. Abneesh Kumar Singh. He's vice president and head of legal and privacy at Vodafone Shared Services in India. So he kind of takes care of legal altogether, but he's also taking care of the DPO work at Vodafone Shared Services. So now he's one of the guys who you can ask about global compliances, because he's sitting out of here, but kind of catering to the world and solving the global compliance problem of Vodafone Shared Services as well. So yeah, so welcome to our webinar, sir. It's good to have you here, and we are looking forward to, would you like to introduce yourself as well?
Sure. Thank you so much, Aakash, for inviting me for the session. And just as a brief introduction, I know I've not done wonders, so the introduction would be brief. I head the legal and privacy for Vodafone Shared Services. Now it's known as Voice. We have rebranded it as Voice Vodafone Intelligence Solutions, because it's no longer only a backend office for Vodafone. It provides innovative solutions to Vodafone worldwide. And the Voice is at this point of time primarily based out of India, which has around 12,000 people, more than 12,000, around 13,000 odd people in India. And the largest center is Egypt, where we have around 6,000 people, in Hungary, and then Romania. We just started Albania as a small hub, and then we have also set up an office in Malaga in Spain. And just to cater to some language-specific services, we would continue to open offices in different parts of the world. Like, for example, Turkey is still in discussion. We are also evaluating some of the West European countries. So that's where our how we are spread there. Now, what we do is, in terms of privacy, is that when we were starting our privacy program, there were lots of discussions where, India not being a GDPR country, what sort of framework do we need to have? And then eventually it came from the group that, in terms of jurisdictions, we would not deviate from the framework. So the framework applies to the European Vodafone European units as much as it applies to us. So we've tried and followed that framework to the T. And while it has been cumbersome, say the least, but I think it has worked wonders for the privacy function, at least, because we are closely knit with the group and the opcos. When I talk about opcos, these are the operating companies, the telecom companies in the Vodafone world. So, for example, Vodafone Germany, Vodafone Spain, Vodafone Italy, etc., would be the opcos, and they are the primary customers for us. In terms of doing certain activities in privacy, we are actually audited every year, and there is also an evidence-based testing that's being conducted, which rates you, different parameters, how you are. And we are actually doing much not much better. We are doing we are the best at this point of time, despite being a non-GDPR country, in terms of every evaluation that has been conducted last year. So,
right.
And that also creates confidence amongst the customer as to the way we secure their data, and also it's also a sort of business enabler. So I know the introduction went on a little bit more long, but then I just wanted to also tell you all what we do in terms of privacy and how we have managed to do it well. Yeah.
No, it's definitely it's one of a learning space for a lot of companies in India, because India is also known as the knowledge economy, right? So we may not be the number one manufacturing hub of the world, but we're definitely number one manufacturing hub of talent in the world. So you name a company and their CTOs, would be Indians, right? And it's interesting to see how is that possible. But then the knowledge economy kind of speaks for itself. So I have a few disclaimers before we start the session. So the presentation and discussions are not legal advice. Our speakers are not representing their companies. They are not, their advice as well is not legal advice, right? And that is all for disclaimer today. We are cutting short on disclaimers nowadays. So the agenda of the discussion, so we'll get into CCPA, CPRA, the differences. Then we'll get into some scope and applicability, something around enforcements. What are the principles compared to GDPR are different? What are the consumer rights which changed after CPRA? What difference was there in CCPA and CPRA? And what are these case scenarios of vendor rights, right? Like as vendors, what are these case scenarios that we can talk about? We'll get into this. But guys, just wanted to, before I start the session, there's a small survey that we're doing, obviously. But the question is CPRA a new legislation and a different legislation? True or false? Is this new? Is this something new, or is this something that got updated or something? No, but or if you don't know the answer, maybe, guys, right? It's not a problem. Whatever questions you have, please feel free to post them in the chat box. If you will post the questions in the chat box, I will take all those questions and ask Mr. Abneesh, as well as if I know something, I will try to answer as well. But the goal of the session is to answer your queries, to solve some queries, to give some gyan, right? And that is the goal of the session. So, and in achieving that goal, you will need to ask some questions and I will need to answer some answers, right? So please be sure that, okay, so we have more than 40 responses, so we'll get ahead. So the answer is no, because CCPA was already there and CCPA got updated as CPRA, right, in the US, especially for California state, right? So we're just talking about one state in the US, which is California, and we're talking about consumer privacy rights in California, right, which is CCPA, but we'll come to that. So CCPA versus CPRA, right? And because we already know that, this is something, this is not new. So this is something that is coming from somewhere. And it is coming, the CCPA was the base that came out earlier in 2020, 2018, but 2020, I think it got, activated, or the CPRA kind of came out in 2020. So Mr. Abneesh, what would would you like to, also help out our, audience to understand, right? What are these differences between these two, right? What are these high level differences between these two? Why did it change, and what did change? Yeah.
So first of all, it's slightly intriguing that, sometimes when we see US legislation around privacy, you'll find that, they are slightly behind the curve compared to EU's, and that's very intriguing sometimes, because, they have, front runners in terms of civil rights for most part of the history. But yeah, I mean, I think California is ahead of this for a reason, because they are the ones who have guarded those privacy rights much more stringently than any other state in US. So I think one of the things that I would want to talk about is that, the scope of CCPA was slightly limited. So while there was a right to delete personal information, there was a right to opt out of the sale, right to non-discrimination, right to know about the personal information business collected, etc., etc. In terms of enforcement, and because why GDPR became such a novel kind of a legislation, because of was its enforceability. So in terms of enforcement, the statutory enforcement is somewhere around $750, if I remember correctly, and and that too, there is a cure period in the CCPA, etc., which was not making sense for people for many reasons. And there was a reason, there was a intention of the legislators to modify this and bring the privacy to the fore of the consumer rights, whereas in CCPA, it was primarily a consumer right where privacy was being embedded. Now it seems like the privacy will come to the fore and the consumer right will take a backseat. So that's the some of the few things that I think, and I know there are additional right in lines of GDPR that has been embedded in CPRA as well, and now it slightly in terms of sensitive personal information being introduced, which was not there in CCPA earlier, and the right to forget, etc., and data minimization, the principles that you inherently is a part of GDPR, those have been inbuilt in CPRA now. So those are the finer prints that I could see in terms of the changes in the legislation itself. I mean, you would like to elaborate if I've missed out something, because that's what
I think it's something overall. But I know there are a lot of topics that we want to discuss, so I will move ahead as well. So CCPA went into effect on 1 January 2020. Tsaaro got founded on 1st January 2021, and CPRA will come into effect on 1st January 2023. I don't know why 1st January is such a great date. So Americans love it, maybe. Right. So, but it's interesting. It's interesting that they're putting 1st January to the date, and 1st January is coming, right? It's coming, and a lot of our clients are coming to us, and they want a gap assessment, and they want to understand from us, what is this gap that they have, because they have already implemented GDPR and CCPA. So, what is this gap left? So, this is something that we are doing day in and day out nowadays. But yeah. So, guys, I have a small question for you. Is there a provision for establishment of supervisory authority under CCPA? The question is very important, because without a supervisory authority, there cannot be enforcement, there cannot be fines, right? So I'm just giving you the link again, right? If you use the same link, then it will work with you again. But do you think that there is a provision for establishment of supervisory authority? And if you don't know, just choose maybe, guys. It's totally fine. So, Mr. Abneesh, what is the right answer? Do you think there will be a supervisory authority now, or do you think no?
No. So in the earlier legislation, the authority was Attorney General, if I remember correctly. Now I think California Privacy Protection Agency would be formed, and they would be the supervisory authority. and they would be responsible for investigating, enforcement, and the rule-making powers.
Right. I think so. So basically, there was always a supervisory authority, but it is just that now, yeah, there will be a dedicated one.
Right.
Yeah.
So it fell under the Attorney General. The earlier Supervisory Authority was both with Attorney General in US.
Yeah. So guys, yes, and we will also move ahead into the session. But I think Mr. Abnish, what is also happening, right? And I don't know if this is happening to all our listeners today, and people who are also contributing with us today. And I don't know how many compliance heads, DPOs are on the session. Let's have this conversation going. So the problem that I've seen with my clients, right, with my DPOs that I am assigned to, and plus the academy that we run, right? So most of the privacy professionals are around there, right? They're doing service, so they are already there in that academy. So this is a question that is coming in, right? That people want to understand what are these key changes, right? Because this is a question that is coming around, like what is changing around rights? What is this criteria that is changing? What is this new category of data? Are they adopting GDPR? What is this? These are these changes. What can you shed some light on this?
I think, to be very honest, I do not have an answer to that. But I think most of the changes that has been brought by CPRA, I think those have been modeled, and I'll say modeled because I have not been able to go to the final prints, but from whatever I have learned is that the principles around GDPR has been adopted. For example, the rights around minors, the right of enforcement, uh, uh, data minimization principles, those things have been modeled under GDPR. I think one of the important reason for CCPA not getting that kind of attraction in California was also because of the fact that there was a 30-day cure period for the organizations to for any violation as well. So even if the consumer had any issue around their personal data being used, the onus was primarily on the consumer to prove that they had suffered the financial loss, and only that loss was being covered. And otherwise, there was a minuscule fine of $750. But that too, if the organization was not able to demonstrate that they have cured the breach within the 30 days period, which was not a very ideal kind of a situation. So because of that, it was thought that there has to be a model change, because if you don't change the model of the legislation, it becomes very, very, the legislation needs to have some so I think that was the important reason why CPRA was brought into fore. And they have created a mechanism now where there would be a legal actions on breach. GDPR principles have been adopted. The minor rights have been secured. SPI has been introduced, etc., etc. So I think this is a welcome change. In terms of business, I think what CPRA does is that it has enhanced from the earlier CPA provision of 25,000 people. I think it has moved to 50,000. The numbers have moved up, but I think it also has introduced a concept like sharing of information, which was not there before. So these minor changes, I think that will bring more teeth to the legislation itself, and the enforcement will become much more easier. That's my initial feelers about the legislation. So and from where I've read about it so far, and the kind of things that we are trying to do, some of the contracting as well, and the other things that we have learned from experience.
Yeah, and I think we'll definitely talk a bit about contracting as well by the end of when we'll talk about the vendor arrangements that are changing and the contracts that have to change or not, right? Probably we're also going to shed some light there by the end of the session. So pointing out, so I think that kind of gives us a fair idea in terms of where we are and where we are going towards, and especially things like sharing of information, calling them out specifically also makes tons of sense. And I think this is something that is also different from the European standard, the European way of doing things. So I think that is also one thing that becomes very evident in the US way of doing things, right? They are very business oriented, and Europe, I feel, that is very people oriented, right? When you're taking data or going around. So that also is a huge difference that I see around in companies' approach and type of data practices that they are holding. So, but yeah, CCPA was very interesting for me because somewhere we had GDPR and somewhere we had CCPA, where only like after a set of controls or after a point in time it applies to you, and only when you sell the data. So things like that kind of make it very interesting as a privacy professional to see, because a lot of people ask me. Somebody was talking to me, Mr. Abneesh, like I don't know, last week I was just sitting out with them in Bangalore, and they said, Adarsh, recession is coming, what will happen? And I was just telling him that whatever comes, there are so less people in cyber and privacy. What will happen to us? Because there is already nobody out there, right? That can, because privacy, as we start studying, it becomes so complex after 5 minutes, right? That this law has to do this, that law has to do this. There is immense shortage, right? There is internationally now, because, and somebody was also asking me, so I went and met some people in Europe. They were like, why are there so many privacy professionals in India? And I also thought, like, he was like, you don't have a law, right? So why are everybody in India, doing some privacy training or is in some company? And I was just telling them the same thing. I'm like, boss, all the work of the world is happening from India, because somebody here is sitting in an office in Bangalore or Pune or Bombay or Gurgaon, and is kind of catering to the world, because India is a knowledge economy and people here are kind of, solving that problem globally. So it's very interesting that India doesn't have a law and still has so many privacy professionals, right? And I can see the same professionals now learning a lot, moving out to Dubai, Ireland, right, around the world. But it's interesting, right? Even when I was teaching CIPPE today, the second page of that trainer module also has somebody who is a DPO at one of the very famous telecom companies in the US, right? So it's very interesting that everywhere, you see somewhere, that some work is getting done here. But yeah, it's something that I kind of found out. So applicability, right? The game of applicability. So I think today also we are just teaching and learning, what applies, what doesn't apply, right? Even in GDPR. But like even today, like, the question still comes whether this will apply or not, and still there is no answer. But we are getting mature as an organization and as privacy professionals. So moving on to also CPRA and CCPA. So sir, what do you think was in CCPA, which is still there till December, by the way, but what type of applicability will change? I know you pointed out sharing of data, right? That is something that you pointed out, but also from a customer's point of view and also from an organization's point of view. Let's say I am a company in India. I am Infosys, right? Or I am TCS of the world. Now, earlier I'm doing business in California, right? My clients are doing business in California, right? So would that affect a company like me in India because this is changing or not?
Yeah, so I think the change in the criteria actually means that start off with, let's talk about numbers first. Some small to mid-sized businesses that have to comply with CCPA may not fall under the scope of CPRA, because CPRA increases the threshold of consumers or households in criteria A from 50,000 to 100,000. So the new law may actually reduce the number of businesses that would qualify under that threshold. However, as I said earlier, the inclusion of sharing related to deriving 50% or more of an annual revenue in criteria C, actually, the third criteria, that is, will potentially increase the number of organizations that would have to qualify as a business under that threshold. Because I think sharing is an important aspect of what companies do, and it has become very automatic these days, without much control and governance around. So while selling is important, companies also do share information around that. So if that were to also to be accounted for, then in that case, I think more and more companies will start getting into that umbrella. That's my initial feeling uh, about the applicability and the outreach of the legislation to start off with.
Yeah, I think, and also if I summarize this, so threshold is that then the revenue of selling or sharing has to be more than 50%. The PII needs to be of more than 100,000 households, alone in combination by cells, and annual gross revenue is $25 million. And only then, we will, so basically the bigger fishes, right, will be caught and catch in action. And, the regulatory agencies also want to spend more time on the bigger fishes in the world. And sharing is not caring at all in privacy world, guys, right? It is morely selling or, selling of data. So it's also a very interesting concept. So yeah, over to the next question. Right.
Hi guys, I just have one question with these three applicabilities. The second point with regards to annual buying and selling and sharing, would this be direct or would only, or would it include the indirect mode as well? Any thoughts on that?
So I think if the regulation as it explains this, that if there is a sharing and there is an accountability attached to that sharing, then even if that is indirect, it would be a part of that sharing. So it's not necessarily that you directly share, but if some part of the sharing and the sharer is accountable for that information, then even indirect sharing would come into the purview. But to be very honest, I don't know much about this, but that's
Okay.
my understanding.
Okay, all right, thanks.
So yeah, I think we will. Yeah, hello. What could be the impact of? Okay, so I think we also have a very important question here. It's what could be the impact of removal of devices from the threshold, right? So, but I think what I will do is I will come back to this question as well, right? So I will just get my team which is working on CCPA to answer this, and yes, and I will come back to you. It's a great question, by the way. It's super tricky, and this is a very important one. I also published this blog on this. But yeah, coming to the point. So enforcement, CCPA versus CPRA, right? So if you look at three major pointers, right, and we've been discussing about this as well since start of the session. So what do you think, Mr. Abneesh, right, in terms of enforcement when we compare CCPA and CPRA? So what are these changes you see between the two different laws?
I think there existed an enforcement agency in way of the Attorney General, but we'll have to understand that Attorney Generals in office in US caters to so many different kinds of matters. Well, there wasn't any tailor-made agency to look into these violations and redress it. And I think that was an important aspect why this has been introduced. For privacy protection and enforcement. And I think this will go a long way, because we have seen in other legislations as well, including GDPR, that enforcement is one of the fundamental reasons why people have started complying with GDPR. And it becomes not a very healthy way to do that, but that's what we are. And so I think that's an important part of the legislation. Is for me, it's very, very, very important. I think some of the privacy rights have also been modified, not modified, actually quite a lot, because, earlier minor rights were not covered, SPI were not covered. Individual rights in terms of how their information was gathered, how they could control their data, etc., were not covered in CCPA. Now those are explicitly mentioned in CPRA now. So I think those individual rights have become very important. And then, of course, I talked about organizations having a right to cure their breaches, non-compliance. I'm sure it's not a very healthy way to do things, because when an organization knows that they will always get a cure period to make right the intentional wrong that they are making, then it does not make sense sometimes. And individuals had in CCP, individuals used to have a very worried time, claiming their right, and if they were not able to prove what actual financial loss they have occurred, then the statutory fine was very minuscule, around $750, which was not enough, and that is something which companies can always live with. So enforcement was not appropriate. The cure period was something that was tilted towards the organizations, etc. Now those have started to change drastically, and then that's something that I'm really very positive about this.
Yeah, and I think when somebody has this time of 30 days to not cure, I think that nothing is cured, right? So, and even as professionals of privacy, it becomes very difficult to tell the leadership that they need to follow something, because otherwise a lawyer would come in and say, hey, privacy policies and practices are fine, but this may not make sense to do, because you still have a leeway and you still can play around with privacy rights of people, right? Even if a breach is happening, so you can play around security of the company. So I'm just saying these things are demotivating factors for even the CEOs of the company to take action, right? To do something about privacy. But it's very interesting to see. But I would rather say I feel great to see the journey of California, because when you look at CCPA, it came first, and then CPRA is coming, right, where the enforcement is increasing. And in India, right, maybe this could have been a great position, right, where we started with something, half of the law, and then maybe in 2-3 years we could have changed something. But we did not start. We started on something very difficult, right? So the Indian narrative and the Indian narrative got paused in between because of the data localization. But it's interesting that the law that we hear about the law coming in again, and it will be tabled very soon. But it's interesting to see that at least the journey of California, right? I know that unfortunately dots only collect backwards, not forward. So now when we look back, right, their journey looks much more smoother, right? Because now towards enforcement, at least companies know something, rather than like GDPR, where last day was a D-Day, right? 25th May 2018 was a D-Day, right? I know all the Fortune 500 companies, all the biggies of the world, they were just running here and there because there was neither a privacy professional, neither they can ask anyone, neither the privacy professional also knew what to do, right? So everybody was doing something. So I do remember that day that the enforcement action was getting live, and we were not celebrating that day at all. I know these days people are definitely celebrating GDPR day and everything, but 2018 was not a celebration for sure, right? I can guarantee you guys that's something that had happened. You should ask people around, right? The amount of lack of knowledge we had. So yeah. So coming on to consumer rights, right? So let's just quickly go around and see what is there in CPRA now, and what kind of got added and what is there as well. So somebody who's there for the first time and just listening to CPRA, I think this will also make a lot of sense for you, because rights and principles are all a law is all about. So right to knowledge, right to know and access was there in CCPA and is still there in CPRA. Right to rectify was not there, but it's there in CPRA. Right to delete was there and is still there. Right to restrict processing was not there, and now it's in CPRA. And now right to data portability was there and is here. So the only two differences in terms of rights that we see is right to rectify and right to restrict processing have been added. So basically 5 rights have been added. So I was reading the last slide, but right to opt out. But I just want to kind of point out back also, because when I kind of mention, is there a chart that I can make here? Okay, so if you look at CPRA, right? So if you look at, pardon me for my drawing, it's like, I'm just still learning that. So if you look at CPRA or any law, so there are two things that we have to look at: rights and principles. So CPRA logically, end of day, would become a text of principles and rights, right? So the new principles being added and new rights being added kind of changes everything, because the text that is written may look pretty straightforward, but the moment you go, so how do you comply, right? So a lot of people ask you, right, how do you comply? So this is just the start. Principles and rights, changing principles and rights is just the start. Because now take an example, right? I know a lot of privacy professionals are in this section. So now let's take an example. Let's do a PIA. So when I do a PIA on CPRA or CCPA, if I compare both of them, what am I checking? I'm checking the rights and the principles, whether they are going or not. And if they are changing, then my PIA template is changing, my questionnaire is changing, my risk format is changing. Now, when I'm doing privacy by design, then obviously it's obvious that the design is what? Design is based on the principles of the law. So now when I will do a privacy by design assessment on CPRA, because the rights are changing and principles are getting added, then obviously that the template will keep increasing. Right, and then we have more questions to ask and more topics to satisfy, more controls to satisfy, and we will have more risks, right? So just adding on to what is also going to happen, right, next. But understandingly, what I also feel, other than applicability metrics, if I look at the things that are being added or things that are changing, they are not very different from GDPR, right? CPR is getting closer to GDPR in my eyes. I don't know. I would like to hear it from Mr. Abneesh as well. So what is your thought? I think what I feel is CPRA was a bit far from GDPR, but now with these changes that are coming in CPRA, it's getting closer to GDPR. Obviously, there are a few differences, right? There are differences, and I'm very cognizant about that. But the more I get into the session, the more I read about it outside and discuss, then I feel that we are coming closer to GDPR in California.
Right. I think CCPA was started off as a more of a consumer right in California and had a tinge of privacy. But with CPRA, it's lesser of a consumer right. It's more becoming a privacy right of an individual, the consumer. So it slightly tilted more towards privacy rights of the consumers rather than being only a consumer right. So I think, yeah, I think California has been taking baby steps for long, but I think it's probably a more methodical way to move to a full privacy regime. And I think CPR is a right step in that direction. So what I'm assuming what they're trying to do is that, they built in a legislation, then let people sink in that legislation for a couple of years, and then people become a little bit more comfortable. Then they try to make the laws a little bit more stringent and in favor of the individual rights. So I think that's also a corollary of what you said before. In India, we were trying to create a law which never came to fore because we wanted to have a very picture perfect kind of a legislation, which we were not able to do that for certain reasons. But in California, I think they have done it a very right way, because US there has always been a tug of war between the privacy right versus law enforcement agencies' rights as well. Where one will take precedence over the other. So in that aspect, I think this is something that they have done.
Yeah, also I feel that a lot of times everybody is behind US, right? That they are like, I don't know. I also have a perspective there that everybody is behind them. That they are not giving privacy rights and they have national surveillance policies. But I think US also is unfortunately the most attacked country in the world, and we as Indians can understand because of our north regions, right? We can understand, but for US it's important also that they do surveillance. So I get the point that privacy is important, but for them that perspective is also important. I know as a privacy professionals wearing the specs, sometimes we just feel that, hey, no, this is privacy, but my journey also started with a bit of security controls, and I feel that when we start doing that, it's important that we also keep the hackers at bay, right?
Right.
And yeah, and that kind of is a, it's a tug of war, right? But privacy takes precedence, but still, I think information security also should be thought of, right? So guys, do you think, okay, I think this is my last question to you today. So just one last question, and I think then probably we'll also come towards a Q&A session and also towards the end of the session in next 5 minutes. So do you think that CPRA takes any inspiration from GDPR? That's very true that privacy is a fundamental right in India and it's not in USA. It's something that is interesting. But the pressure, I think, is more because I guess that economy is much more developed and much more ahead. So their pressure is different and our pressure is different. I think our foreign minister was saying somewhere that our per capita GDP was $2,000 per person. Though we are still the fifth largest economy in the world, but still. So yeah, we need to eat first, right? So yeah. So adoption of principles. So there are 3 principles of GDPR that got adopted under CPRA: data minimization, storage limitation, and purpose limitation. Right? They were not in CCPA, but now they are in CPRA. So these 3 principles, including the rights that we were talking about, will become a part of your PIA, privacy by design metric, general GDPR framework. So please add them, guys, right? So, and that addition is very important because the date is coming. It's 1st January 2023. So it's time to kind of, update your privacy impact assessment templates, your ROPA templates, your data processing agreements, right? It's high time now to kind of take action and, just get those things aligned with the new California Privacy Rights Act. So we will also come towards the end of the session now, and we'll open the session for Q&A. So if you have any questions, right, please drop them in the chat box and we will take them one by one. Yeah, I think we are waiting for the federal law in the US. And once we have that, I think probably a lot of other problems also, like transatlantic data flow, though they have signed an executive order to kind of, manage it right now in the US between EU, but still, once we have a federal law in the EU, in EU, then I think problem will solve altogether and not just right now. It will take some time, take some more laws to sort it out. But yeah, the amount of complexity that is increasing because all the states are bringing up their laws it doesn't seem like the best option right now, right? It doesn't seem like the best solution for a global company. For a global company, the complexity is just increasing, right? And we have also have to do business, right? So, and that kind of thought process kind of, is not there yet.